legal challenges to the IEEPA tariffs. I'm Teddy Downey, executive editor here at the Capitol Forum, and today's guests are Kathleen Claussen, professor of law at Georgetown University, and Beth Baldson, senior advisor at the Capitol Forum, and former counselor for trade and investment to U.S. Trade Representative Katherine Tai. They'll be talking with us about the legality of tariffs imposed by President Donald Trump under the International Emergency Economic Powers Act. Kathleen and Beth, thank you so much for doing this today.
Thanks for having us.
Great to be here.
If you have questions for us, just email them to editorial@thecapitolforum or just enter them in the chat feature here in the control panel. But you know, I think you know, we're really going to be diving into the legal merits here, Kathleen. And if you could sort of set the stage for us on the challenge to these tariffs and sort of the arguments on both sides, that would be a great place to start, and then we can dive in from there.
Sure, sounds good. So I think unless anyone really has been living off the grid, most people will be tracking somewhat of where we are and know that we're going up to the Supreme Court here in a couple of weeks. So let's get started, as you said, with the arguments. So there are a number of different challenges to the tariffs, and so I mentioned that because there are really about 12 cases that are in motion here, but only a couple that are making their way to the top. But all of the challengers have very similar arguments, and those arguments are, firstly, that IEEPA, the International Emergency Economic Powers Act, does not permit the president to impose tariffs. That's argument number one. That's the top of the list for what the Supreme Court will be thinking about. And why are they making that argument, or how are they making that argument? Well, if you look at the text of IEEPA, the language, the pertinent language, says that the president can regulate importation of foreign goods. So regulate importation. Some people would say, well, that does not say you can put a tariff on a product, right? And others would say, well, yeah, regulate importation, of course that includes tariffs. So that lack of explicit reference to tariffs or duties is what the challengers are centering their primary argument on. And I will leave that for further discussion in a moment. The government says, of course, it's implicit, right? That's there. And that'll be, as I said, the primary question for the court. We can again break down why they feel so strongly in each direction, but let's start with that first question. A second related question is whether, if you say that regulate importation does allow the president to put tariffs on products, is that unconstitutional because it doesn't put a limiting principle on what he can do? So that's something we call the non-delegation doctrine. It'll be familiar to all the lawyers on the call. And that, again, you have to have some sort of limit to how the president can carry out this work. Now, why is it that there has to be a limit on what the president does here? Well, that brings us back to a fundamental starting point for all of our discussions in trade law, U.S. trade law, and that is that Congress has the power in our Constitution to regulate commerce with foreign nations and to lay down duties and tariffs. So everything that the president does in this space has to be through a statute. IEEPA is the one he's invoking here, and we'll talk about some others that he could invoke in the future or has invoked in other contexts. But I just want to make that point about why is it unconstitutional potentially that IEEPA would allow tariffs. It's because the president's full tariff authority, if any, comes through statutes. It has to come through statutes because otherwise Congress is the one that has this power according to the Constitution. And when Congress delegates its power, it must be limited according to the non-delegation doctrine. Okay, so those are really the top 2 points. And as I say, the first one is one where we're all focused. The second one could be another pathway to the same outcome. The third kind of lingering question that's out there also has to do with the emergencies that the president has declared. I think it's pretty unlikely that we're going to get into this before the Supreme Court, but I just want to mention it because a number of the challengers have done so. They are arguing that the emergencies the president has declared, either the one with respect to fentanyl and bringing in migrants and those related to the fentanyl tariffs, or the one about the trade deficit, that those are either not appropriate to be emergencies in the sense that IEEPA is thinking about, in the National Emergencies Act, which goes hand in hand with IEEPA, or it's the tariffs aren't an appropriate way to deal with those problems, which is again the language of the statute here. So ordinarily under IEEPA, it's a two-step. First, the president declares an emergency, and then the president can act, regulate imports or whatever he may do thereafter. There's a long list of things he can do. And so this other set of arguments has to do with that preliminary step. Has this emergency, are these really emergencies? Have they been appropriately declared, and do the tariffs deal with those problems? Will they deal with those problems? So those, I think I'll stop there, Teddy. Those are the three sort of leading arguments on the part of the challengers. As I mentioned, the government has sort of the opposite position that you can imagine, thinks that a regulate importation does mean you can put on tariffs. The government also points to how President Nixon relied on a statute that was basically the same language, not exactly IEEPA, but its predecessor statute did the same thing. So we have that sort of precedent out there. And the government also in response draws from this sense of the president has this foreign affairs power as our commander in chief, as the one who negotiates treaties. And he should be allowed to do this under that power as well. So as I said, I'll stop there, but that's what those are the main things that we're talking about as we head up to the Supreme Court in a couple of weeks.
I have my initial reaction here, and I would like to get Beth's reaction as well, is my understanding is that this non-delegation doctrine was like sort of recently made up sort of fictitious thing that the Supreme Court did to just get its way on whatever it wants that would be favorable to big business. But the way that you lay it out is that it's not, I mean, is that in this instance, there is actually more explicit authority over trade for Congress. And in that respect, it sounds like there is some legitimacy to the argument, whereas if you had said, hey, their main argument is non-delegation doctrine, but like, well, that's made up anyway. So we'll just, the Supreme Court is just going to do whatever it wants. If it wants to make him the king, he's going to make him king. If he wants to do what big business wants, so what's your response in this, just specifically to the non-delegation doctrine in this instance? Is there some substance there, or is it a fanciful thing?
Let me take on the sort of the legal nuances there, and then again pass to Beth as you wish. So the non-delegation doctrine, that one is a long-standing one, and actually, interestingly, the non-delegation doctrine dates back to some litigation that actually is also related to the trade power, and so we'll spare our listeners the historical details there. But non-delegation doctrine has been around for a while. It's very similar though to the major questions doctrine, which I didn't mention, but it sounds like maybe what you're thinking of here. The major questions doctrine is more recent, right? It is a doctrine, or at least in its present form, the way we talk about it as the major questions doctrine is something that we've been talking about much more in recent years. And that's a little different because that one is referring to how we interpret statutes. So that is when we look at the IEEPA and we're trying to discern what does regulate importation mean, the major questions doctrine would guide us in our interpretation to say when Congress delegates its power, such as here, it's delegating this foreign commerce power, it must speak in very clear, explicit terms, because this is a major question. That's how the logic works on the major questions doctrine. It's not so much about the limiting principles as non-delegation doctrine would be, but it's more about the sort of explicit nature of what Congress has done here. So just laying it out one more time, it says that when Congress delegates something that is major, as we would say, this is here, right? To be able to delegate such authority that would affect the global economy, the national economy, this is how the argument works, then that means it has to do so in very clear terms. And to say regulate importation covers that. that is not clear enough under the major questions doctrine. So that's I think perhaps what you're thinking of here. And yes, and so folks, there are folks out there who say that's an invention of the Roberts Court. It's a more recent thing, and the court can then wiggle within it, make the major questions doctrine be whatever it wants it to be. And so those critics, I think, would say then that here they'll just be wiggling their way through a major questions doctrine that actually is or is not what we should be looking at in the course of this case. But let me throw it over to Beth if you wanted to comment on that.
Sure. I think for my part, what I find fascinating about this case and both the non-delegation doctrine and major questions is the degree to which it is a reflection of what I would say ideological fight over neoliberalism. And part of it is that for the last 80 to 90 years, Congress, especially on trade authority, has progressively delegated more of that power that it possesses to the executive branch. And frankly, from my perspective, not ever thinking it would be used really to raise tariffs. It was this idea that the president would be the one to progressively get us to lower and lower and lower tariffs. And so here we arrive at a situation where all of that delegation that Congress has done, Congress is now in some quarters saying, whoa, what have we done? But to my mind, and I worked for Congress and I loved my time there, but it's hard to argue that some of Congress's muscles haven't atrophied over this course of conduct to just shift all of these decisions to the executive branch. So now the chickens are coming home to roost. What I see, I would consider myself a lapsed lawyer in the presence of Kathleen, but when I read these decisions, I think to myself, this fight over whether you can or can't define regulating imports to include tariffs, to me, just from a common sense perspective, I think you can, but there's fuzzy language in almost all of the decisions where that clean question morphs into, but he can't do it like this. This is too much, this isn't right, he's gone too far, it can't mean this. So what happens when it gets to the Supreme Court? Happy to dive into that, Teddy, on sort of my thoughts on that, but just to be responsive to that last part of the conversation.
Can we, I would actually like to go back for 1 second and just focus on the non-delegation doctrine, because I have definitely gotten that confused with major questions and just sort of paired them as sort of lawlessness masquerading as legal theory. So can we talk a little bit about like the legitimacy of this non-delegation doctrine and like whether you find it compelling in these arguments? Or, I mean, my initial read of what you're saying, it strikes me as Beth that like, yeah, it seems like you could easily say that regulating imports would include a tariff. I don't see how that actually, I'm having a hard time seeing how it doesn't. So from a non-delegation, aspect, maybe just a minute on the legitimacy of that or the history without necessarily going too deep into the weeds, if you don't want to do that. But that is interesting, I think, and then how you find whether or not the argument's compelling.
Shall I start? Is that to me, Teddy?
Yeah. Kathleen,
okay, great. So there's a lot there, but to be concise here, I think, let me say that the rule behind the non-delegation doctrine really is about, is there an intelligible principle that guides the president in his exercise of delegated authority, right? And so what is that principle here, right? That's what folks are arguing about. The problem, or perhaps challenge, I think, about non-delegation in this context might be that trying to differentiate between this little sliver of regulate importation and the rest of IEEPA, right? Because the other parts of IEEPA, you look down the list, right, basically, as I described, it's a two-step. He declares an emergency, and that unlocks a lot of powers. Right? Once the emergency is declared, he can regulate, or he can do. There's a prohibit. There's a long list of verbs really that he can do with respect to that. And in case folks are unaware, although many may be, the IEEPA statute is the basis for our sanctions program, among other long-standing economic powers that have been used by the executive branch, and that we're all, I think, okay with. You may quibble as to the use of sanctions against person A or person B, or country A or country B, but sanctions in general, right? Long-standing program, not something that we want to mess with. So the problem here is if we say that the IEEPA lacks an intelligible principle for the president to do things, then you risk basically taking down the whole thing, not just this tariff authority. So that, I think, is a reason to think that maybe the Supreme Court might not go down that road of using non-delegation to choose to strike down the president's authority if it wished to do so. So that's it, I think, Teddy. It's the concern about the rest of IEEPA, not just the tariff power.
Beth, any thoughts there?
I defer to Kathleen on those types of things.
Okay, and then so coming back to this, what do you find to be the most, is there, if we're saying that one's tricky, the non-delegation argument, what do you find to be I guess just taking a step back, is this really going to be a close call, when it comes to the merits of these arguments, or is the other argument they're making, more compelling than the non-delegation doctrine?
Oh, well, there's a couple different things there. So, it's hard to say what's going to be the most compelling here. And I say that because I truly believe that. I think it's there are so many different pathways here for the court to reach either outcome. Right? And I always say, if I had a crystal ball that worked, I'd be a much wealthier woman than I am today. But I certainly don't. And I wouldn't begin to guess how each justice will approach this question. But what we can say is that there are a lot of different pathways. I mentioned several of them, and those pathways, I think, are each of them in their own right. You just said, you could see how regulated importation could lead to tariffs, and so who knows really how each justice will approach. I could expect we'll probably have multiple opinions, and each of them could take a different position on any of the strands that I mentioned. We're coming up from the federal circuit, right? So this is a consolidated case now, really, of 3 different originally filed cases. But if we're looking at the case that we have, the decision we have from the Federal Circuit Court of Appeals, in that instance, it was a much closer vote than I think many people thought. If you listened to the oral argument in that case, most trade lawyers and others who were listening said, gosh, it really sounds like the court is against these tariffs. And they were in the end, but the vote was 7-4. It wasn't a slam dunk, right? It wasn't 11-0 or 10-1, right? So 7-4. And then if you look even closer in breaking down the opinions in the Federal Circuit's case, then in that instance, you had some judges, the majority stops short of saying that tariffs are never allowed. It says, as Beth referred to earlier, it says that these tariffs, the way the president has done those are not allowed. But they didn't go so far as to say only some of them, right, in an additional opinion, said we would go farther. We would say IEEPA never allows tariffs. So that already tells you, right, you've got 4 judges, right, from the Federal Circuit kind of clumping around different ideas. And so I think we could expect very much the same with the Supreme Court, that we're not necessarily going to be slam dunk for anybody, but different clumpings with different rationales as to how they're going to get to their final outcome.
Can you maybe we can talk about those pathways a little bit more? I'm interested in these pathways that allow Trump to do it, just because I think there's like a bit of a consensus that they're going to not allow the tariffs because Trump has other methods of doing tariffs. take longer and, have more process, and, you can sort of split the baby and give Trump king-like power on the one hand, but also do what business wants, and that's sort of the middle ground for a conservative Supreme Court. But how he keeps the power, how the Supreme Court ends up giving him the emergency authority here. What even if there are a lot of pathways, I'd just be interested in the most compelling legal arguments, or I know that's a big loaded term, but how you see the most, the one that has the to your mind would be the best pathway from a legal standpoint to allowing him to keep the power.
Again, Teddy, this, I mean, maybe asking the impossible to some degree there. I think, as you said earlier, if we asked 10 people on the street, does regulate importation mean tariffs? I mean, you can put a cost on those, right? Put a fee essentially on those imports. And then probably if we said nothing more than that, I think a lot of people would say yes. Then if you said to people, okay, can you put a tax? Can we tax things just with the word regulate? Is that enough to put a tax on something? I think that number would go down. So a lot of this case is about framing. If you're framing it, if you think of this as a tax, then people, again, generally, if you took social studies in elementary or middle school, you think, the tax power, that was pretty important in our nation's history. And we are pretty sensitive about how we do that and who we let do that. And that's something really that Congress should and could do. Do we really let the president have a blank check on how he does taxes? No, we don't. But if you think of this as the president is our foreign policy person, he's the one who represents the United States in all of our international engagements, then you might start to think, okay, he's just acting really in a foreign affairs-y sort of way. Now, it's the latter one that in particular, that in my research, I've been trying to argue with my co-author that's actually not how the founding fathers thought about the foreign commerce power. They didn't think of it as something part of a general foreign affairs power, which of course doesn't even exist in the Constitution. It doesn't say he's our foreign affairs guy, but rather that's a pretty clear distinction that Congress had from the beginning, and not one that the president had. So that argument, I think, is on the weaker side, to say, the president's always been our foreign affairs person. But again, I think it really does come down to these sort of framing issues, whether you see this as a tax and therefore, the president can't tax without more guidance or more power that hasn't been given to him here, or whether you see it as more as an international, he's just doing this really for the national security of the country, which is how a lot of our statutes that delegate a power to the president are framed.
Can I jump in on that, Teddy? Because I agree about the framing, and that's why I think part of it that is making judges really uncomfortable is just the sheer scope of the tariffs. It's on friends and foes alike. When I was at USTR as a career lawyer, I actually, you don't expect this when you go to the trade representative's office, I had an equal protection case, and litigating that with the Department of Justice, you appreciate the degree to which judges are people. They want to feel okay for the most part about the decision they're making. I think a lot of these judges don't feel okay about totally unfettered tariff power. On the other hand, if, for example, the first thing the president had done was 100% tariffs on India for Russian oil, and that had been the first case, I don't know that the arguments would be exactly the same. There wouldn't be, to my mind, quite so much pressure on, is regulating imports, are you allowed to do a tariff? And so I think the scope of it is actually bleeding into the legal analysis.
Just to jump in, Teddy, yeah, so that's been something I totally agree with Beth that I've been saying for a while, that if we only had these secondary tariffs, these so-called secondary tariffs, the ones where he's declared Russia as a threat, he's declared Venezuela as a threat, and therefore tariffs on countries, on products from countries that import Russian oil or import Venezuelan oil, that those are allowed, then yeah, we wouldn't have the lawsuits that we have. You wouldn't have the same, these are very interesting plaintiffs that have brought these suits, either very teeny tiny importers or that are funded by certain think tanks. These cases, and I don't think you'd have the same sort of outcry, or the Democratic states that have brought the one case. You wouldn't have the outcry, you wouldn't have the litigation. But bear in mind too that the Supreme Court will be thinking about that. The Supreme Court will have those sorts of cases. A colleague of mine who works closely with the Supreme Court on Supreme Court matters is always reminding me, the Supreme Court is going to be thinking through all the possibilities of how this authority could in the future be used, how in the past it was used. And so that is going to influence how the justices approach this question. What's possible if we come out with X, if we come out with Y? And so some of these things I think are going to be important in their decision making.
And maybe one fact just to introduce, because Teddy, you were saying, what about the pathway? If the Supreme Court wanted to let it stand, but not have it really be infinite, then perhaps one option, if I'm not mistaken, that Congress has repeatedly now prohibited itself from exercising its authority to override the president, if I'm not mistaken about that. So they've had riders, maybe in the appropriations bills or whatever it's been, where they've prevented themselves from voting the tariffs down, which you could interpret as Congress saying, we're actually okay with what he did.
This is so fascinating. So we've done the path to letting them go through. I know we've set up the framework so you could just switch it and say, okay, well, if you interpret it a different way, you could just go the opposite direction. But and before we just go fully into the politics, what is the path? What if we're thinking the reverse, and you're like, okay, the most compelling, the cleanest arguments for getting rid of it, is it as simple as just flipping that frame and calling it a tax and just like leaning into that, or are there other compelling factors, like there are all these other more explicit authorities, and like how do you explain those? If why does one take 2 years? Why would you ever do the one that takes 2 years if you could just do it in 2 minutes? And then lastly, I actually remember thinking, well, this whole like calling it an emergency and then having it being totally unrelated was actually interesting, but you seem to say, well, we're not going to get into that because, and I'm curious why that is not a more likely argument to come up. Is it just because it's such a low bar to declare an emergency, even if it's like kind of unrelated? So I know I threw a lot at you. I promise everyone I have a direction I'm trying to go in here. But Kathleen, if you could start off with the path for the other side, and we can eventually get to all the 12 questions I just asked.
All right, let me pick from a couple of them there, and then Teddy, you can re-ask as you see fit. But so let's start with the last one about the emergencies and deal with that language is that the actions the president basically have to deal with, right? He can take action to deal with these problems in the emergency. We can talk more specifically about legal language if folks want to, but that's the gist of it. So the reason that I was sort of less enthusiastic or put that on the back burner in my earlier presentation of the arguments, there are a couple of reasons, but I think the most important one is, yes, what you were implying, deference, that we give a lot of deference, that judges, courts tend to give a lot of deference to the president when it comes to these issues of national emergency, of national security, of things that sound like war issues, right? But again, the national security premise is one of those spaces where we've repeatedly seen from the court in the federal circuit we mentioned earlier, in cases from Trump 1, we've seen the court rely very much on this sort of deference position in dismissing cases or in supporting the president's use of the tariff authority in those cases. And so that's the trend. That's the practice typically. And DOJ is leaning into that here, right? DOJ is saying, as I mentioned earlier, oh, this is all part of the president's national security, right? That the opening arguments and that the government has brought in a number of these cases have been related to that, suggesting this is all wrapped up in the president's national security authority, and we shouldn't touch it for that reason. Then let's see what else we come to. Oh yes, so yes, there's an argument from the challengers in some of these cases that because there are other statutes that allow the president to impose tariffs, and those statutes are very carefully circumscribed, they have limits, they have processes, they involve agencies, unlike this one. Then because those all exist, then this can't possibly have been what Congress intended. Those statutes were on the books already, and so Congress knew those statutes existed, and so they couldn't have possibly intended in writing IEEPA, as they did in 1977, for it to be as broad as the president is interpreting it to have been here. And I think that ties in well with what Beth was saying earlier too about it's the scope here, and that was what the Federal Circuit, the majority said. It's, again, we're not going to rule out that regulated importation could someday mean tariffs of some sort, but what he's done here is too much. Even when Nixon did it under the predecessor statute, there were limits. He said he was going to be limited, and he was, and so that was sort of the comfort. But again, here, interestingly, Teddy, the government is not really sort of harnessed the position of the Federal Circuit and relying on that when it comes to Supreme Court now. It's not, and again, maybe a variety of reasons, but I think it wants to preserve all these statutes and be able to pick and choose from them as it can. But it has not really, sometimes what we see, right, is if you win on which, here there are a lot of different strands, but if you have a decision in your favor, or that could be interpreted in your favor at the lower court, and now you're going up on appeal, right? You want to say, oh, right, the court here said this, and you should, take some piece of that or whatever. But the government is not doing that here. The government is taking the sort of stronger line position that it doesn't matter the scope, where the president can do this, and I think that surprised some people. But it plays into the whole, again, the first part of your question, or what I took as the first part of your question, that this is an emergency, right? The government is really taking on that as its central premise. We have to move fast. We got to go to the Supreme Court right now. We got to play up the emergency, and you've heard the members of cabinet. They've put this into their briefs. They've said, this would be a disaster, right, if we don't get to keep these tariffs. So everything that DOJ is doing is really grasping onto that security emergency sort of thing, and that is I think some of the reasons why we're seeing sort of that tenor come across all of these briefs and so forth. So for a meandering question, you got a meandering answer.
I love it. No, that was fascinating. I mean, Beth, did you want to add anything here?
I would just add that the same anxiety that people have over the scope of tariffs, which is bleeding into the question of whether you can use tariffs at all under IEEPA, is also happening on the emergency side, where what he said in the proclamations and executive orders is different from what he's saying on Truth Social. So the emergency, again, getting back to that, judges are actually people. When you see that it's not really about fentanyl, or it's not really about the trade deficit, it makes you uncomfortable with giving him unfettered authority to declare an emergency that you feel might be pretextual, while you're very uncomfortable telling the commander-in-chief he doesn't have unfettered authority to declare an emergency. So this is one of the, you learn at a law school, bad facts make bad law. You know, you have a really tough case, and it forces you into having to make some very, very hard choices that in more stable times you had been able to dodge.
And going back to the path question, are there any other things about the path to knock down the authority that we should dive into from a legal argument side of thing? I mean, I find you have all these other very explicit authorities for this type of thing pretty compelling on its own. And I also, you know, historically, I mean, maybe less so recently, the Supreme Court has looked at, you know, real world consequences. You know, obviously there's like billions of dollars in commerce, you know, of tax or tariff or whatever, you know, being imputed on industries. So there's a real world consequence either way, right? Either they're going to have to pay them or they're going to have to get reimbursed. And so it's just a huge deal. I'm curious if that factors in one way or another on either path, or if it's just sort of a mixed bag. You know, I could see it being in favor of keeping it just because, like, well, those payments are already being expected at this point, but from a legal standpoint. But is, you know, are there other is that worth talking about in terms of the path to not doing this, or not giving president authority here, or are there any other kind of legal issues that we could dive into on the path to saying, you know, you have to use these other authorities?
Well, yes, there are other, you know, still more in the weeds, but let me just pick up the point you were making, Teddy, about refunds and or sort of the real burden that importers will face if these continue. So each of those has different sort of following thoughts on the refunds. So what we're not going to see here, right? A lot of discussion, I think, about the refunds and what the Supreme Court is going to say, because that process will begin right after this. And there are a lot of questions I know out there on the part of importers as to how would that happen. There are deadlines that are approaching. How would the government ever handle that burden? And could customs even manage it in the first place? How would that happen? Would it be the normal process? Would it be a special process? So those are all sort of outstanding issues that, yes, if the Supreme Court were to say refunds are owed in due course, right, then we would have years of litigation, I would expect, in trying to sort that out. Beginning with, will there be an administrative process that will be special from the normal one, and how would that be managed? So I think you're starting to see importers, knowing that those deadlines are coming up, those importers are now trying to prepare themselves, right? Either bring lawsuits or whatever they need to do to protect their rights, should that come to pass. On the flip side, on your other point I've now lost, but what I was going to say in response was that, in a way, that this litigation is, I say to at least to foreign governments and to some importers and investment firms that I speak with on occasion, it's a bit of a distraction, right? And why is it? For the reason you said, is there's so many other tools, and so we can expect to see tariffs are continuing. There is no doubt about that. Tariffs are a popular tool of the man in the White House, and they're a popular tool among his cabinet. And so how the Supreme Court comes out here and the pathway that it takes, yes, that will be important, of course, to people in the immediate and in the long term. There will be lots to take and to digest from whatever the Supreme Court says. However, whether you're concerned about whether there will be tariffs or refunds, the fact of the matter is, the answer is there will be tariffs, and they will come very quickly. If the Supreme Court were to say these can't happen this way, they will come very quickly. So I think the important point here is that regardless of what the Supreme Court says, we're going to be in this position, and therefore there will be litigation in either circumstance and either outcome.
And Beth, anything to add there, or
just that I think there's also at play potentially for the Supreme Court whether or not they are inclined to let these tariffs stand. There will also be some concern. I mean, the man likes tariffs, as Kathleen was saying. Will they want to really open up the floodgates so that he has genuinely unfettered authority to do any amount of tariffs under IEEPA? So that comes back to whether, even if they're okay with the tariffs currently under litigation, do they find a way to cabin that in so that we are not on a path towards 70 trillion percentage points of tariffs going forward, which he likes tariffs.
And that brings me to another question, which is, we've got the two paths. One's the Trump wins, one Trump loses. Beth keeps bringing up these sort of middle ground paths where, you sort of split the baby in some respects. Are there a lot of paths in that sense where you could kind of come up with some kind of, well, we're going to let you have the authority, but you can only use it for X, Y, or Z, or you can only use it when the other authorities don't apply, or I don't know what kind of compromise is possible, but are there, of all of the paths, are there paths like that? And, obviously we don't have to go through all of them, but if they exist, maybe we could talk about one or two that they could do.
It's still within IEEPA, Teddy, not beyond in the other statutes, right?
Yeah, or however you would consider legally splitting the baby. I guess that's some threshold question. It has to be like either allowed or not allowed. But I suppose if you're allowing them, how are you curbing them? Probably is the most sensible way to split the baby here, I would imagine.
Yeah, so the Supreme Court really is not in the business of sort of drawing the diagram, right, of this, but they are in the business of saying, right, yes, no to this, and giving, some usually language as to why the yes, no to this, and that's what people would read very closely, which is what we saw from the Federal Circuit, right? The Federal Circuit said, these go too far, but maybe sometimes you can use IEEPA. That's sort of what's there between the lines, and in some places very clearly. So then you have to ask yourself, well, what options are there for the administration if the outcome is the same, very similar to what we saw at the Federal Circuit? Then you would expect the administration to go back and revise to then try and come within the terms of what guidance they do get from the court. And so that's, I think, not out of the question, to the extent this is what you're asking, that if there's an opening to still work within IEEPA, just not the way they have done so to date, then they go back and they issue new executive orders that say, okay, every situation normal, carry on, everyone, we're going to keep doing the same thing, no changes in the tariff rates or whatever, right? And we're just going to write this language of the EO, of the executive order, differently, or we're going to put a time limit, or whatever guidance they seem to take from that. And then, as I mentioned, we may be back in litigation again to see new challenges to the way they do the new executive orders if they were to proceed that way. So I think that's what would happen, Teddy, is if the Supreme Court gives any license to the president to proceed under IEEPA, just with some limits beyond the ones he has now, or whatever he's put on them so far, you could expect the administration, I would think, to go back and just revise and carry on.
There's a decent chance we might just be met with more confusion and uncertainty after this decision.
And I think that's inevitable, right? No matter what, up, down, we just carry on. I mean, there's an argument. Some would say, well, if it's better for everyone if they say, go for it, Mr. President. You just carry on. We bless this IEEPA use because then there's the least amount of disruption because it's at least whatever we've been doing for the last 6 months is going to continue for unless he himself makes more changes, which of course we all know could happen and it will happen most likely. At least the Supreme Court will not have disrupted what is already a disruptive environment.
And Beth, you want to?
I just wanted to add something else that someone mentioned a couple of weeks ago when I was on a panel in Brussels for the Atlantic Council. Somebody who thinks about the bond market pointed out that the bond market might be dependent on these tariffs. So Teddy, to your point about the business community, it's actually a little more complicated than if you're factoring in the tax cuts in the one big beautiful bill, and the fact that the bond markets maybe have been okay with the deficit because of the tariffs. And so that's a dimension that may also factor in, just looking at the Supreme Court and how they've treated Governor Cook versus Commissioner Slaughter and their sort of concern for the foundations of the economy. That got into my head a little bit about how they might also look at these tariffs.
Just see if I can maybe tell you, just Beth reminded me of something, as I think that was an important point in mentioning that big bill, a lot of folks have also been watching for a while to see if Congress will bless what the president's doing, right, or intervene against what the president's doing. And I think we all can see the very obvious political gridlock in which we find ourselves at the moment. But I think that we shouldn't rule out congressional action in some degree. There have been attempts, not happened so far, but let's see what's coming. And there again, you either add to the disruption or you calm it down with something more long lasting. But that's again a much longer conversation.
And I think I'm going to ask this question in a way that allows for both maybe a legal perspective and a political one. But Kathleen, if it's just too obviously political, we can have Beth answer it. But there are, there are a lot of groups, you just mentioned the business community, who are clearly weighing in here that have had influence with the Supreme Court. You've got corporate executives, you've got the business lobby, you've got states. So you have these constituencies that are weighing in, and then that's a tension with this general interest in the Supreme Court giving the president king-like authority and coming up with doctrine that would allow him to have more power. How do you see that, how do you see that tension from a legal perspective in, the arguments that are being made by these, business groups that have been influential? Is there any way to impute that legally, or should we just be doing it strictly from a political perspective of like, okay, they're doing a political analysis for how this is all going to come out?
Who the constituency is doing it? Give me
who people who are weighing in, with briefs and things like that, or the business community saying, hey, you shouldn't do this. How does that factor in from a, with the does that add any weight to on the side of the the people who are challenging the authority?
So you raised an important point that Beth and I were actually chatting about before we began, about just how many briefs are coming forward in this case, which is interesting, for just from a court watcher's perspective, right? That you had this already at the Federal Circuit. You had over 15 amicus briefs from different groups with different perspectives. almost all of them were against the tariffs, against the use of IEEPA for the tariffs. And so what do they bring to the table when all these groups are coming forward, and what can the court make of that? Most of them are tracking the arguments of the challengers, of the plaintiffs, of the folks involved in the suit as the parties, but some are adding more sort of historical reference, right? So there's I think something to be taken away from the what's being added on the side, but it certainly suggests to the court that there's an upswell, right? No doubt about it, of folks who are not happy with it. Now, how the court will take that on is what I said. It's much harder to know. I think you also mentioned a couple other things that I'll just respond to before I give the floor to Beth here. That one is just the behind the scenes, what we're not privy to, but that some of the conversations you hear in the corridors, or maybe are implicit in what's being reported, suggest. For example, the significant business decisions that are turning on the refunds possibility, right? And how investment firms, and maybe some folks who are on the call today, are buying up the rights to refunds, right? And so there's a whole business side of this, right? That it's not necessarily atypical, but when you have these really big tariff-related, trade-related lawsuits, that comes with some of the territory. You see it also in international arbitration, similar sort of patterns. And so that is important. And again, I think that will be on the minds of many. You mentioned also sort of the lobbying that's happening, and I think that's also an interesting point, because if you look, if you look at these plaintiffs, the folks bringing these lawsuits, they're very small companies that are sort of bet the company litigator. They're going out of business, and they say that, and they mean it. They really are going out of business because of the cost of tariffs. Obviously, they're not alone. There are millions of companies across the U.S., right, that are similarly situated, that are facing these sorts of questions. But why are we not seeing the big companies, right, that are clearly affected by the tariffs? Why are we not seeing them in the lawsuits? And that is, I think, to your point, Eddie, there's so much lobbying going on surrounding the tariffs that is not taking place in a courtroom, right? It's taking place in the White House or in our agencies, and that's going to be maybe even more influential than whatever the Supreme Court has to say here, right? Because they're getting exceptions, they're getting changes to the processes, they're forcing reliance on other statutes that, again, we mentioned several times but haven't really gotten into, and so you're seeing this sort of quiet movement behind the scenes, brought on by, I think, very powerful businesses, that at the end of the day is going to be more impactful for the broader trade landscape and the business landscape than perhaps this will be on these very small importers.
If I could just jump in on that, I think the core challenge, as I see it, for the Supreme Court, the majority on the Supreme Court, is that this really reflects the two different wings of the Republican Party right now, which is the libertarian wing that hates tariffs, but Teddy, to your point, the sort of more monarchist wing that does want the president to have essentially the maximum amount of authority. And this litigation is the very, very intensive intersection of those two wings.
Yeah, I mean, the way I think of it is like, who does the Supreme Court feel like its constituents are? And there's Trump, right? There's the monarchical constituency, and there's the billionaires, or just the reporting from ProPublica or what have you about the Harlan Crows and the people who buy them stuff and or otherwise have outsized influence over the court. And it's like, which are you going to side with? Are you siding with the king or the business community? It's unfortunate we're not talking a lot about the American citizen or anything in that equation, but it's a tough spot for the conservatives on the Supreme Court, I would imagine, caught between a rock and a hard place at some level. I kind of wanted to take a step back, Kathleen, and ask you, just being do you think that this is really a legitimate rule of law process? Like, does this feel like when you do this analysis, I know as a journalist, I find it confusing and frustrating to do this kind of political analysis and assessment that Beth is talking about, trying to get into the ideology. Is it like a good faith or bad faith? Is there a rule of law here? What's your just overall sense of where we are in the courts? Are you more optimistic that this is actually real? There is a rule of law in place, a legitimate process. I'm just curious. You're coming at this from a different perspective. I think Beth and I are just so cynical, and it's refreshing to be talking to someone like you. But I would like to get your, how you feel about it and what makes you optimistic, or what makes you kind of stick to the law, comfortable doing that, or just your general assessment of where we are here when it comes to bringing things before the Supreme Court.
Teddy, I am a civil procedure professor. My daily bread and butter is teaching students about how our court system works, and that requires a degree of faith in that system that I continue to have. And so I think the bigger question here is what comes on the other side of these decisions. If the Supreme Court is to start ruling against the president's, or in certain instances, if we find that the Supreme Court were to strike down the president's policies in trade or anything else, what we want to see is the maintenance of the system in which the administration then adjusts course in response, and so that's I think what we are watching, and that all of us should be watching going forward. But my faith in the courts is not expired, Teddy. That's again what we do in law school.
It's great to hear. We have one last question here. Beth, did you want to add anything there, or can I, before we go, ask?
I'll just quickly say I did think that the Court of International Trade decision was very good and very disciplined, and did reflect a serious attempt at rule of law.
Last question we have here. Implications of demise of Chevron deference if the Supreme Court overturns IEEPA. I don't fully understand what that question is. I mean, maybe we've already kind of addressed it, but does that question make sense to you?
Two questions there, Teddy. I think the first one is about Chevron deference, and the second one is about other routes to achieving the same tariffs and on what time frame.
Yeah. I left that part out because but yeah.
Here in trade space, there's some differences that apply, but to the way we think of deference to what applies to the president versus what applies to the agencies. But the questioner is right to ask something like that, because some of these trade statutes did allow for Congress to make changes after the president would act, and post Chevron, this case for those who aren't aware from the 1980s, post that time, with those sort of safeguards gone away, there's a question really for what can we do to stop the president from going off the rails. That's basically a very, very quick abbreviated way of thinking about that. But in trade, there are some differences, and so I'll just put that out there. The second question, I think, as you said, we've talked about some of the alternatives, although not in detail, and the questioner there is also right to ask about the time frame for proceeding with these other statutes. And since time is short, I will just say that I would expect the government is working on that right now, and has been working on that probably for many months, so that if the Supreme Court were to disallow IEEPA tariffs, they will be able to pivot very quickly to using any of the other authorities, what we call what I call the three-digit tariffs, that are likewise available to the administration. So I think we could see that happen extremely quickly, like days. And some of it's already happening, right? We're already seeing a significant reliance on 232. We're seeing more 301s, including yesterday. So just a variety of options for the administration that will take very little time to put into place.
Beth, anything to add?
Nope, that sounded good to me.
Well, Kathleen, this was an amazing conversation. We threw so many things at you, so many questions. I learned a ton. This was just an awesome conversation. I can't thank you enough for doing this.
Much for the invitation.
Beth, thanks for doing this as well. And thanks to everyone for joining us today. Amazing call as always. And this concludes the call. Bye, everybody.